I think it's an important point and may have been missed given some of the discussions earlier today. The importance of curtailments in times of shortages is to protect lawful uses of water. A lot of discussion about senior water rights. I look at it again a little bit differently, and the purpose of protecting lawful users of water extends to or is intended to protect those diverting water available under established priority of right. And it's more complicated than just senior water rights at times. And second, water right principles allow for diversion by those who are junior if they're diverting previously stored water. And obviously an important component of the discussion and why reservoir operations exports are contemplated here is protecting the release of previously stored water for the intended purpose, whether it's outflow, exports, beneficial use by those that were previously storing the water. I would add that protecting those that have contracts with reclamation is important. I think this was in the letter provided to you by Northern California Water Agency and others. We do think that there needs to be a special treatment or different treatment for those that contract with reclamation but hold water rights separately. Settlement contractors, as an example within the Sacramento Valley, that they should be should be allowed to continue to divert based upon the terms of their contracts and as allowed under the contracts. Second point.
I don't mean to interrupt you, and it won't take your time. That is part of it, right?
Yes.
Right,
that would
yeah,
be-
that's my assumption, but I don't
Yes.
think it had been said explicitly. I meant to either correct or illuminate some of the comments people made, so thanks for bringing that up.
And I will try to speak. I don't think there's a button here to turn the mic on. A second point is if the state board pursues an option that includes emergency regulations, I think there's some important principles that you should adhere to.
Okay.
First, I think it's very important that the state board affords interested parties an opportunity to review and comment on the draft regulations before they're presented to you for consideration. And second, that the regulations adhere to the priority of right that's been established by law and do not address wasteful and unreasonable use or the public trust balancing. And the basis for this latter point, that the regulation should not address waste and unreasonable use or public trust, is that those are principles that need to be considered on a case-by-case basis. Third, the San Luis and Delta Mendota Water Authority does not support the state board adopting emergency regulations that expand the application of Term 91. That we don't think at this time the state board should be using authority, taking any action that assigns responsibility to other water users for water quality control plan requirements.
So wait, so you mean not to do number 3?
Yeah, either option 3. I guess I look at the options 1 through 4 as straw proposals, and where you come out is yet to be determined, and it may be one of those or may not be. It may be a fifth option.
Right.
And yes, if I'm looking at the 4 options that are before you today, option 3 is not something we would support. We would not support any alternative that used the current drought circumstance to expand the responsibility for the water quality objectives beyond where it is set in D1641.
I'm not sure that, help me with this, I'm not sure 4 does.
I'm not sure if 4, I don't think 4 does.
I don't think 4 is
No,
intended to.
4 does not.
Okay.
I agree with you. I don't
Okay.
think 4 does.
I'm just trying to understand.
And then 2 comments based upon some of the statements made earlier today. We heard from, I think it was Diane Riddle, that she was not recommending the use of information that's been submitted, specifically, if I heard her correctly, use of information on statements of diversion and use. And she characterized those as not being accurate and thought that the board should adopt something that used more of a calculation like the Term 91 type calculation. I would note, hopefully you're noting that There's a process that requires statements of diversion and use. There's legal requirements that is intended to have those statements based upon measurements. And the fact that those measurements and the statements are coming in a way that's not useful is hopefully something that you consider and correct so that we have better information in the future. And then the last comment that I'll make is in response to a statement that I heard Les Grober make. And again, if I heard him correctly, he was suggesting that upstream curtailments in the Sacramento River and the San Joaquin River were necessary in order to ensure there's water in the Delta for diversion by what he characterized as senior water right holders. And that is, I don't understand that argument. And my understanding of the circumstances are based upon, in large part, findings that the State Board made in D-1641. And the first finding that I would note is, I'm sorry, this is a statement that you made in D-1641, and the statement is that your order, WR 89-8, concluded that Southern Delta riparian water right holders have no right to water from the Sacramento River. And that's on page 33 of Decision 1641. And so the question becomes, why would you need to curtail on the Sacramento to support at least the diversions in the South Delta? And based upon your finding, I don't think there would be a basis. And then the second piece of information that comes into my mind is flow at Vernalis. So what is the natural flow at Vernalis going to be during the summer? And I don't know what the natural flow will be. But what I do know is that the projections of flow, and obviously it will either be natural or return flow, but the projections of flow is something around 350 to 450 CFS. And that may be an overstatement if you ask some. And I go back to D-1641. And in the proceedings leading to D-1641, South Delta Water Agency identified, and you relied upon exhibits that South Delta provided on the diversions that occur in the South Delta that they've asserted are riparian. And the diversions that they identified are 1,400 CFS of diversions in July, about 1,330 CFS in August, 1,060 in September, 902 in October. And so the question becomes is, if there's not natural flow to support those diversions, why would you curtail upstream in order to allow for continued diversions in the Delta? And there may be a reason. I just was very surprised to hear that, given the statements that and conclusions that the State Board made in D-1641. And so with that, I have no further comments. Available for questions.
How would you propose that we approach it then?
Well, I think one of the concerns I have is there's been a lot of discussions, and a lot of the discussions have been painting this very broad brush. And I just don't see how you can do that and adhere to the priority of right. And so with my example here at the end, Les's statement in my mind was a very broad brush statement, which I don't understand. The way I look at it is similar to the way that the State Board looks at it, and maybe I'm influenced because of the statements of the State Board. But I would look at, you have diverters in the South Delta. They've historically claimed that they have riparian rights. If you were to assume that the diversions in the South Delta are riparian, question is are there natural flows to support those diversions? You've said that they are not entitled to Sacramento River water. Under natural conditions, the Sacramento River water would not make it into the South Delta. Therefore, you go to the San Joaquin and you ask, what is the natural flow there? And if you assume, and it's, I think, ultra conservative, but if you assume that all of the flow at Vernalis in the summer is natural flow, Mr. O'Loughlin indicated that it's not, just based upon his 17,000 acre feet, I think, number, or 17, yeah, 1,000 acre feet number. that there's a reason for you to start thinking about curtailments in the South Delta.
So, the chart that, the curtailment chart that was up earlier, Sacramento, San Joaquin, in response to my questions about, well, I thought we were just going to go by each watershed. Would, looking at the system as a whole, present the problem that you just outlined?
I think in areas. I mean, yeah, I think that as you, and I'm not an expert on this, but I would think as you get into different places in the Delta, under natural conditions, you may have flow from both the Sacramento, San Joaquin. But that's where I think it's very a difficult task, but you do need to be looking at what flow is available that's not natural. What flow would be available under natural flow at a particular location or in an area. But I agree with your comments that you stated earlier. Again, it's this broad brush. It's very difficult to deal with, and if you don't focus attention in at least in areas, I think you do run the risk of running afoul of water right priority.
And so on option number 4, and I think staff put this together because I had some concerns with option 3, and so I appreciate them putting it out there. But well, first of all, there's not enough meat on the bones, and we recognize that. We need more information. But in light of what you just said about this, concern with the broad brush approach, do you have any comment on option 4? And if you have concerns with option 4, what could we do in order to utilize an approach with more real-time data, recognizing the shortcomings of option 1?
Well, I fall in the camp of others that have been before you today. I'm not sure if I fully understood option 4. The way I understood option 4 it was essentially an alternative to option 2. That it was option 2 was using statements of diversion or information that was submitted, and option 4 was using the calculation. But they're all both under the regulation, and neither of them were intended to reassign responsibility for the water quality control plan. I can't tell you, frankly, if the statements are better than the calculation. What I would say is you have to use the tools that are going to give you the most accurate information to ensure that you're not curtailing diversions by somebody who's either junior or allowing somebody to take previously stored water that they're not entitled to.
Right.
So
Both,
have a
yeah,
better-
both are important, so trying to meet both objectives, that's right. That's right. Do you guys want to illuminate? I know you can.
On the observation regarding South Delta and
That would be helpful.
everything Mr. Rubin says is true as far as I'm aware. I think there is a policy debate that could be had about where the various delta diverters, where the source of their water needs to be, especially when they're at sea level. But the board has, in the past, opined on the matter and made its determination. Doesn't mean that it's necessarily cast in stone. But it is a subject that I think we have to address. I only wanted to point out to you that, the purpose of our discussions today is for post-1914 appropriators. We are fully aware of all the nuances of dealing with the pre-1914, the Delta, the South Delta issues, the other Delta diverters, and that was what we were going to tee up for you next, because this post-1914 curtailment is, it's already warranted. Quite honestly, we're already creeping into these other areas. And so after this gets sorted out, we'll be dealing with the very nuances that Mr. Rubin identified.
The much more nuanced nuances.
Yes, it's much more nuanced. Nuances.
Thank you.
Stephanie Morris, General Counsel for the
Thanks.
State Water Contractors,
Ms.
and I will
Morris.
join in Mr. Rubin's comments. And then just briefly, one thing that I was going to say, and I'm glad to hear Mr. Howard address, is that this is a step in the right direction, and we support curtailments as long as they're consistent with water rights priorities and we're protecting stored water. But according to the supply and demand curve, post 1914 is just one step, and on this curve, we're already approaching the meeting of the supply and demand for riparian
Right.
and pre-1914. And so I'm happy to hear, and that was going to be our request, that those also be addressed to protect senior water rights holders and stored water. And then one more brief point is, I think there's been a lot of discussion people going past each other
Yeah.
today. And what I just wanted to point out is, when we're making releases, the projects upstream, it's not just temperature requirements. We're also making releases, as you all know, to meet outflow requirements. And that water has to travel a very long, long way to get to the point where we meet those outflow requirements. And I think that that's it's not that we're going to be saving more water and other senior water rights aren't going to be getting their water because we're storing water in upstream storage. It's that the water that's released for that purpose makes it
to its
to the
purpose.
destination,
Yeah.
so that additional water from storage does not have to be released to make up for those depletions that are unlawful. So
Right.
I think
That was
needs
more
to be-
clearly said than
Yes.
many of the things I tried to say in the last 2 days.
Well, thank you very much for your time.
All right, Dan Kelly, Carmichael Water District, and Byron Bethany Irrigation District.
Sorry, if I could just let you know that Les and David have returned, and they're ready at any point back on
All right.
item 12, just to...
I would actually like to
wasn't
let
say that.
a relief valve of more of the comments on item 13 for the people who've been waiting patiently all day. As much as I know they're also, I'm not being facetious, truly interested in item 12, but thank you for letting us know.
And thank you, Madam Chair, for letting me continue. I do appreciate that. The ping-ponging is getting a
Sorry.
little distracting. and
I'm
so
sorry.
I'm still trying to make sure that I'm actually focused on the right agenda item. So hopefully I don't talk about item 12.
You
Dan
can if
Kelly
you want.
with Somex Simmons and Dunn. I'm here on behalf of Carmichael Water District, Placer County Water Agency, the Byron Bethany Irrigation District, and the Stevenson Water District.
Oh, more.
And I'll just say at the outset, I actually think option 1 is the way to go. And I think that if you do curtailments, and if you do select option 1, I think, as Board Member Diadamo said, I think it should be on a watershed by watershed basis. I think there's a lot of reasons to do it that way, and I'll kind of give you a couple of examples. I was interested a little earlier to hear a conversation about folks that said they're the senior water right holders on the San Joaquin River. And then I started hearing the priority dates they were kind of giving to you, 1911 and 1920. And well, the Stevenson Water District is at the confluence of the Merced and the San Joaquin River. Colonel James J. Stevenson settled that land in 1852, and by 1880 had 25,000 acres under irrigation. So those folks have an 1852 priority date for a great deal of their water rights. I actually consider them rather senior as well. I know that they do not have the position that curtailment should not occur. That water district would like this board to enforce water right priorities to ensure that their senior water rights are protected, that they can continue to divert water under their right. The Byron Bethany Irrigation District has pre-1914 water rights, and they're located in the statutory delta. I think that for that district, their position is the same. If you've got folks upstream or maybe downstream on the San Joaquin River that are diverting with junior water rights, 1911 and 1920, that the Byron Bethany Irrigation District shouldn't be shut off with a 1914 or a 1913 priority. And so I think that really emphasizes why we need to look at a watershed by watershed basis when curtailments get imposed. You've got different factual circumstances all up and down the valley, and there's going to be water available, whether it's through accretions, discharges, return flows in different areas at different times. I think a blanket approach in the entire Delta watershed just simply doesn't work. And if you think about the reverse of the curtailments, when curtailments get lifted, hopefully it rains.
Yeah.
October, November, whenever that's going to be. And when it does start to rain, I suspect curtailments will get lifted in discrete areas of the watershed and not wholesale. We may get late spring storms up above Shasta that may allow some of the folks on Antelope and Deer and Mule Creek to divert a little bit more water this spring. but that's not going to provide additional natural flows down in the San Joaquin Valley to divert water. And so I think doing it in a more discrete manner will, in a more discrete manner, will make it easier to manage throughout the term of the irrigation season, and hopefully throughout the end of the drought in the fall. And so for that reason, I think option one really is the way to go. I don't think emergency regulations are the way to go. And I want to talk a little bit about the enhanced enforcement. And I don't want to quibble really with staff's articulation of that enhanced enforcement authority you have. But the big deal about SB 104 and your enhanced enforcement authority isn't the $500 a day that you got for violations of emergency regulations you adopt. The big get that the State Water Board got through those through SB 104 was the $1,000 a day and the $2,500 an acre-foot penalties that are imposed for unlawful diversions. You have that without emergency regulations. The $500 a day is an ancillary fine that was tacked onto that bill. The big enforcement stuff applies whether or not it's a violation of emergency regulations. In addition to that, the $10,000 a day for violations of a cease and desist order have nothing to do whatsoever with emergency regulations. You can adopt a cease and desist order if someone fails to cease diverting. You can issue a cease and desist order and impose that same penalty. So emergency regulations are not a prerequisite to you issuing a CDO and getting those enhanced penalties. And so I just want you to think about that when you're trying to decide whether or not you need to do it one way because it's more streamlined and easier and there are larger penalties associated with it.
Thank you. That's helpful. And do you have an opinion about the public health and safety exception?
Yeah, and that's a tough one. But I mean, the reality is, you know, water right priorities are harsh. The priority system is a difficult decision to administer, and just because in other ways easy doesn't make it the right way to do it. There are a lot of public agencies that might be placed in some pretty difficult positions if curtailments come. I hope that nobody's going to go without water this year. I've heard from the Department of Water Resources that the list of communities that were subject to possible curtailments that would deprive them of a water supply had gone down to maybe one or two throughout the entire state, and I think that those were groundwater. Those were municipalities that relied on groundwater. And so, you know, I don't know that that's a real issue right now. It certainly may become a real issue later in the summer or early in the fall. I suspect that as we've done in droughts of the past, that there will be market transactions that occur to get the folks that need water at a market price that will avoid upending the priority system. There is no health and safety exception to the water right priority system. There just is none. And so you're going to try to create that exception to the water right system. And you know, if it's not effective, if a court determines that you actually can't do it, I think we're not really in a better place than we are today. I think we're better off working within the system that we've developed over the past 150 years and implementing that system.
Okay, thank you for answering that question. People have alluded to it without being specific, and I was going to invite people to be more specific, which I did a little bit earlier.
Well,
so thank you, as long as you were being so clear on the emergency reg issue.
Yeah, and I, you know, that, like I said, it's a tough one, and part of my concern is how that emergency health and safety water was treated under the temporary urgency change petition. You all heard about that at the workshops on the TUPC, and we couldn't even really define what health and safety water was, and there was a quantity of water that was being diverted, and nobody knew what was happening to it. And I'm more concerned that the health and safety exception gets abused, and it actually ends up upending water right priorities more than it's intended to under a purported health and safety exception. So I have additional concerns about that. I do have just a couple more minor points. Option 3, I think, I don't want to say dead on arrival, but it's, to me, that violates every principle of water law. It violates the El Dorado case that you all litigated against the El Dorado Irrigation District. There, you tried to impose Term 91 on El Dorado's permits that had a 1920, 1926 priority, and you imposed it because you said that they shouldn't be taking water, that the projects should be entitled to store, and they've got to release more water. And the Third District Court of Appeal told you can't do that you've not made a finding that El Dorado should be responsible for meeting delta outflow requirements or delta water quality requirements, and overturned your decision. It baffles me to think that we're now going to try to do that. What the court said you couldn't do in a formal board order, we're now going to try to do that through emergency regulations. It just makes no sense to me. I don't think it's productive. I think that if you're going to take action to enforce water right priorities and administer the system, you should do it in a way that you believe will be enforceable. Because if you take actions that are not going to hold up, there are going to be people that are going to be lined up to march into court, and they're going to challenge you. And if you choose a path that's not sound, that's going to be overturned, then this effort will have been wasted. So I would, again, just recommend option 1.
Thank you. I'll let staff respond to it later unless you want. You want to respond right now, briefly, sure.
Well, I'm
Go
not an
ahead.
attorney, but I've been told over and over again that what the El Dorado decision said was that we couldn't do it to a 1926 appropriator unless we did it to all of them.
Right.
So that's why option 3 does it to all of them.
That was concise. Thank you. All right, Paul Manassian.
Ladies and gentlemen, I'm
He's got a
representing.
card for 12 and 13.
Yeah,
So go ahead.
I'm going to make my comments briefly, and I'm going to do something a little different than I had originally anticipated. I'm representing today the exchange contractors, a number of listed districts in Northern California. And I think we've lost you already, so let me take you 3 years hence. And you're sitting in the governor's office. And the governor has put out a bond issue for additional storage, and it hasn't passed. And there's been a proposal for some method of getting water across the Delta reliably in an earthquake-prone zone. And it has not succeeded either. And he asks you, what is it that caused this problem of a lack of voter confidence and a lack of consensus in the water industry by those that need reliability? Okay? Do you go to Mr. Moore's question? Did you depart from the system because it was too onerous to hold an evidentiary hearing in regard to whether or not somebody had a right and whether or not they exceeded that right? How much trouble is that? You conducted a hearing here yesterday and today in regard to item 12. You had excellent questions. You wanted facts. It was terribly disorganized. But basically you're saying to the governor, who's suffered these losses, about to leave office, what went wrong? Was it that you departed from the system when you adopted that first urgency order and took over operation of the 2 state and CVP project and said you can't deliver any water, even though the water rights said it? You sent a shudder through all of us.
Can I just stop you there? Because that is not what we did, not what Tom did. And that has been repeated erroneously throughout the valley. And I don't appreciate that. Because that is not what happened. Tom said yes to a request, and that has been misleadingly sent around the valley in a way that got in the way of rational discourse. So use another example.
Exactly your answer to the governor. We took action, we didn't intend it, and it created a total disassembly of the confidence that people have in the system. Now, just take the health and safety applied to municipal use. You've got a community that's run out of water. Your staff put that in these emergency regulations. I would have done the same thing if I wanted to get something through. But think about the ramifications of that. You're saying that if there's a community that needs water, 50 gallons per person, they move into a higher priority than anybody else. You know, we've got a system, they take it. We've got a system for that. It's called adopting a resolution of necessity, setting a amount estimated damages to that alfalfa grower upstream that you're going to put out of order and put out of business for a period of time, deposit it in court and go forward. Now, that's the end of it. You're basically running the risk that you are setting a system that has been developed over 125 years because it's simpler to adopt a fish flow requirement for the whole San Joaquin or for the whole Sacramento or a requirement of contribution to the Delta. It is simpler, no question about it, but you're cutting out the anchors that hold us all together, and you're making sure that we cannot go to the next levels of building the storage that is needed that you all recognize now, with all of our dithering, didn't get accomplished. Any questions?
Oh, that's a good point. You just threw me off on that one thing. Point taken. Lena Tam, East Bay Municipal Utility District.
Good afternoon, Chair Marcus and board members and board staff. Thank you for your patience. I'm Lena Tam. I'm the manager of water resources planning at the East Bay Municipal Utility District, or East Bay MUD. Many of you have had the opportunity to tour the McElmy River, which is East Bay MUD's primary water source that we serve over 1.3 million people in Alameda and Contra Costa counties. It provides on average about 2.5% of the total inflow into the Delta. And in this remarkably dry year, East Bay MUD continues to make releases from Comanche Reservoir to the lower McElmy River to meet fishery flow requirements and obligations under a number of interagency water rights agreements. These required releases will exceed the expected natural runoff from the McElmy watershed from June through December. Similar to the state and federal projects, it's coming from previously stored water. The McElmy River is managed by a set of interrelated agreements. This includes the 1998 Joint Settlement Agreement, what we call the JSA, between East Bay MUD, CDFW, and U.S. Fish and Wildlife Service. It sets the minimum flow standards from Comanche Reservoir to benefit the fishery ecosystem. In 1998, FERC approved the JSA and amended East Bay MUD's hydropower license to include these required releases. The state board also approved the JSA releases in D 1641, amending East Bay MUD's water rights on the McElmy to require these releases. East Bay MUD has continued to make these releases and will continue to do so. In addition to these numerous interagency water rights agreements among the various water right users on the McElmy, addressing the various priorities, a set of agreements between East Bay MUD and Woodbridge Irrigation District, and their attorney is here today, addresses how much East Bay MUD must release to downstream uses. And it addresses the overlapping pre-14 and post-14 water rights that Woodbridge Irrigation District has. These agreements have built-in curtailment provisions in drought years, resulting in releases to Woodbridge this year, for example, being reduced from 60,000 acre-feet to 39,000 acre-feet, or a 35% curtailment. We also have a number of court decrees, like the Lodi decrees, that imposes a physical solution on the McElmy between various parties like PG&E that we have agreements with and downstream water users. Together, the JSA, the Interagency Water Rights Agreement, and East Bay MUD's own water rights obligations provide a complex but a successful framework for management of the McElmy River, even during times of drought. The practical effect of this framework is that East Bay MUD releases from Comanche Reservoir to the lower McElmy River are protective of fishery resources and senior water right holders. And for the remainder of 2014, obligates East Bay MUD to release more water to the lower McElmy River than would naturally be available. As to employing Term 91-like approach on the McElmy, We understand that a primary function and reason for Term 91 is to preclude junior water right holders from diverting stored water releases by the projects. We note that there are no CVP or state water project facilities on the McKelvey, so there is no risk of diverting releases from stored project water. As noted previously, there already exists a number of agreements between our agencies on the McKelvey, and we regulate these releases both to protect senior water right holders, and to protect the fishery. And I thank you for your time.
I have a question.
Yes.
So on the McCollum, you have these agreements. Does that cover everybody?
Pretty much. East Bay Mud's water rights dates from 1923 and 1949, and it covers pretty much from the upper watershed down to Woodbridge, which is the last major water right holder before it goes into the delta.
Okay.
Yeah,
And have you been meeting with staff?
Yes, we have, on a different issue. It's mainly related to the extension of permit 10478 on the Comanche Reservoir project.
yeah. I was thinking that we've heard a similar comment from Yuba, for instance, where, agreements are in place, so project type releases, the old Term 91 approach might not be such an easy fit in that type of watershed.
Well,
I see
right, the
parallel.
devil's in the details in terms of protecting the whole range of not unreasonable impact on other water rights holders and what happens at the delta.
Yes, there are details, but the other thing that I think people need to realize, and I assume that people do, is that a lot of these systems coming about now are just releasing stored water, and so again,
Wouldn't be
curtailment
curtailed.
makes no difference to them.
Right.
They're not storing water, so if you curtail their storage right, nothing happens. If you curtail their direct diversion rights, well, that's what they have stored water for.
Right.
And so, it's a question I always ask when people say, well, can't we settle with this agreement, is, well, what difference does it make to you? And in many cases, it doesn't. And if it does make a difference, then that difference might be important with respect to the issues that we're concerned about. So that's the kind of details we need to work through.
Right. Right. Question?
Thank you.
Okay. Thank you very much. Jonathan Knapp? Is that right? Knapp, yes, at SFPUC.
Good afternoon, Chair Marcus, members of the board. Thank you for the opportunity to provide comments. My name is Jonathan Knapp. I'm an attorney. Is this loud enough? I'm an attorney with the San Francisco City Attorney's Office, and I'm here representing the San Francisco Public Utilities Commission. At the outset, I'd say that, I'll first say that San Francisco supports option 1, and to the extent curtailment is necessary, San Francisco believes curtailment should be implemented on a watershed-by-watershed basis. A few moments ago, Mr. Howard mentioned that the State Board staff is, of course, aware that curtailment of pre-1914 water rights involves many nuances. Our comments are specifically tailored to describe some of those nuances on the Tuolumne River for your consideration. So first, I'm going to briefly describe San Francisco's Hetch Hetchy Regional Water System, but I'll mainly focus my comments on voluntary agreements between San Francisco and the Modesto and Turlock irrigation districts that San Francisco respectfully submits obviates the need to curtail diversions under pre-1914 water rights on the Tuolumne River. San Francisco provides water for municipal and domestic uses to 2.6 million customers in Tuolumne, Alameda, Santa Clara, San Mateo, and San Francisco counties through its Hetch Hetchy regional water system. On average, 85% of regional water system supplies come from the Tuolumne River watershed. Additionally, the Hetch Hetchy project provides hydropower generation for municipal customers. In short, the focus of our comments is that it's not necessary to curtail diversions on the Tuolumne River under pre-1914 water rights to protect senior water right holders or to provide adequate summer flows for fish and wildlife. Through voluntary agreements, San Francisco and the Modesto and Turlock irrigation districts have developed a physical solution that protects the major senior water right holders on the Tuolumne and have provided for increased in-stream flows to benefit cold water habitat for fish in the lower Tuolumne River this summer. So first, I'm going to just briefly describe the physical solution, which is San Francisco's water bank in the Don Pedro project, as provided by the Fourth Agreement. As described in the letter San Francisco sent to Deputy Director Barbara Evoy on April 28, 2014, through the Raker Act and the Fourth Agreement, San Francisco and the districts have developed a physical solution to ensure that San Francisco's junior pre-1914 appropriations will not cause injury to the district's senior pre-1914 appropriative water rights on the Tuolumne River. The Raker Act, which granted San Francisco rights of way for the Hetch Hetchy project, requires San Francisco to bypass certain flows to the districts in recognition of their senior water rights. In 1966, San Francisco and the districts entered into the Fourth Agreement, which established how funding for the Don Pedro project was to be allocated among the parties and created a water bank that allows San Francisco to prepay water to satisfy the district's senior water rights. Thus, because the Fourth Agreement provides an effective physical solution, there is no need to curtail San Francisco's diversions under pre-1914 water rights to protect the district's senior pre-1914 water rights on the Tuolumne River. Now, I'm just going to say a few words to describe the voluntary agreement that San Francisco has with the districts regarding increased in-stream flows on the Tuolumne, specifically for this summer. Similarly, there is no need to curtail San Francisco's diversions under its pre-1914 water right to provide adequate summer flows for fish and wildlife. San Francisco and the districts have voluntarily agreed to each contribute flows in the Tuolumne River that are significantly greater than the minimum flows required by the Federal Energy Regulatory Commission, or FERC, for the Don Pedro project. Thus, rather than the required 50 CFS, the total flow at LaGrange Dam between June 1st and September 30th of this year will average 100 CFS. The purpose of the modified flow schedule is to contribute to FERC fishery studies, other monitoring of the physical and fish habitats, and most importantly, to enhance cold water habitat for fish in the lower Tuolumne River. In addition to helping ensure that the cold water fish populations below LaGrange Dam and the Tuolumne River remain in good condition this summer, the modified flow schedule will also contribute extra water into the San Joaquin and through the Delta. San Francisco is, apart from this voluntary agreement with the districts, on its own, San Francisco is also currently releasing in-stream flows from the O'Shaughnessy, Eleanor, and Cherry Creek and Cherry reservoirs above the Don Pedro project. And so just a few points in closing that I'd like to make. One of the issues for discussion at the workshop today was what criteria should be used to determine whether voluntary agreements are viable alternatives to mandatory curtailments. San Francisco respectfully submits that the State Water Board should defer to voluntary agreements where it can be shown, as on the Tuolumne, that senior water rights will not be impaired and there will be no unreasonable impact on fish, wildlife, or other water quality objectives. Because the water bank account established by the Fourth Agreement protects the district's senior water rights, and the provision of increased in-stream flows in excess of legal requirements will enhance cold water habitat for fish on the lower Tuolumne River this summer and contribute extra water to the San Joaquin River and throughout the Delta, there is no need for mandatory curtailments to achieve these same objectives. In my comments, I referenced April 28th, 2014 letter to Barbara Evoy. I have copies of the letter that I'd like to submit into the record. And that'll conclude my comments soon. Thank you.
Thank you. And I assume since you've written the letter that you all are in conversation and can ultimately answer all the questions that
Of course.
Mr. Howard raised
course.
earlier.
Of course.
Okay. Thank you.
Thank you.
Patrick Porgins? Oh, Tom, did you want to say
I
something?
would only, make the point that the proposal, as I thought I just heard it, was really to act as though the Tuolumne River exists in isolation. But of course, there are downstream water right holders. As we heard John Rubin say, there's a 1,400 CFS demand for riparian demand in the South Delta that the board has in the past said has to be satisfied out of the San Joaquin River.
Right.
To the extent that the 100 CFS leaving the Tuolumne is the entire natural flow or is stored water, then curtailments would make no difference. To the extent that they're actually still storing or directly diverting water during this time, then
Right.
that's being done to the detriment of the downstream riparian users. So, the issues as everything's connected to everything else.
Well, no, that's what I meant, because you raised that, the question of downstream seniors and fish and wildlife, so.
I would just note, if I could in response, that San Francisco was also a signatory to the letter that was referenced earlier today with the major senior water right holders on the San Joaquin River system. And I think that to some extent addresses the concern that Mr. Howard raised regarding riparian interests lower down in the system.
Depends on where you define the bottom of the system. That's the issue.
Just one brief comment to that respect. Yeah, South Delta signed an agreement that apparently said they were willing to forego any flows out of the San Joaquin River. However, that doesn't mean that they were going to cease diverting. It just meant that they were going to take the project's stored water.
Right,
And they
yeah, it's a
apparently
zero-sum
agreed
game.
to do that. So those are the type of problems we have with these agreements.
Right.
Thank you.
Right.
Thank you.
Mr. Chair, members of the board, my name is Patrick Porgans.
Sorry.
And today I'm not even here as anybody other than a witness, okay? I'm witnessing. I witnessed a lot of confusion today, and I'm sure you have. There's a lot of ambiguity associated with what you're attempting to do. And there's ramifications that are probably beyond what we can even imagine. So, taking that into account, I have to say that I'm not in favor of any of the 5 things you got going on. I'm going back to where we got to where we are now. See, I'm one of those type of people. I have to know how I got to be where I am in order for me to be able to go from where I'm at. That's just how I think. Maybe it's a flaw. Maybe I'm an endangered species. Back in 1978, I asked for a full-blown adjudication on all the water in the Delta. I was here. And they'd say, well, that'll take a lot of time. Well, we're now in 2014, and we're still, up in the air. I look at that graph there. I got it under the Public Records Act. There's 535 million acre-feet of water. It's been appropriated. I can't tell you how much is duplicated water because, quite frankly, not even the Division of Water Rights can. I'm sure if we cut out 200 million, we'd probably still have 300 million or so acre-feet of water that's appropriated. We only get about 80 million acre-feet of runoff in California annually, and out of which we use about 30 million. And if you look at the 30 million, we're probably looking at 60 to 40, 60 surface, 40 ground, thereabouts, depending on the type of water year you have. Now, getting back to the issue with respect to some of the things like Benassian and O'Loughlin and others raised here. Evidentiary hearing, you put a lot of time into this, trying to get it together and deal with the emergency aspects. And it, I wouldn't want to be in your shoes, okay? Because it's difficult. You're not going to be able to please everyone. And you're probably going to be putting yourself out there anyway. So no matter how you look at it, you got a catch-22. And from my point of view, what I see here is attrition of neglection for having to take responsibility for dealing with the issues associated with the conundrum that we're facing. By and large, I have to take, I submitted an 18-page, protest to the concept that we have an emergency here. I take exception to the fact that we're not going to have impose or create any difficulties for other water users. You can't say that with any degree of specificity because, quite frankly, we don't even really know how much water everybody's using. In your Division of Water Rights annual statements, which, if the staff even gets time to read them, we are 1 year in arrears on that one. So we don't know for sure, what they're using when they're using it. Now, I've seen a lot of things, and I work for a lot of people in the Delta, for over the 40 years. And we talk about enforcement like as if it's something that's going to happen. Well, you got a CDO out there on the State Water Project and the Central Valley Project, and I still haven't seen when you take an enforcement action beyond the fact that you issued a CDO. Back in 1991 and 2, when we witnessed, and I was out there, I was out there. And I was watching, we were monitoring them. I monitor these projects when I can. Because, see, you're sitting here taking the advice of two of the major perpetrators of the problems that we're experiencing. And then you got a real issue here because, you know, you're appointed people. And like Manassian said, when they come up and say, how come we can't get the bond money? Well, I can tell everybody in this room right now, I'm going to do everything to stop them from getting the bond money because we've got $20 billion worth of bond money out there that's water related. And that's about 20% of the total $80 billion that we got outstanding. And if you throw $20 billion more on that, you know, just to pay the interest off. And then if you look at the 4 major landowners down there in the valley that, you know, essentially have 740,000 acres, you know, and now are paying $2,560 an acre foot for this transfer water. You know, the boys down there, Pom Pom and Pistachio guy. I'm saying to you guys that, look, we've got a real dilemma here. And I can't see how you're going to get your way out of this one. This is something that's been coming at us. And now we're facing it. And I don't know how much longer I'm going to be on the planet, and I can't continue to give my time to you. You understand? I got a wife, you know, that's concerned about the whole situation, you know. And anybody that's been married for a while, you know, for a while, they understand what I'm talking about. So what I'm saying here today is that we're reacting to a set of circumstances that were brought about by an inherent shortage in the state water project. That's the basic issue we got going on here. Now, I can show you data and that, you know, between 2002 and 2008, you know, the Metropolitan Water District and Kern Water Bank and the rest of the guys down in the valley increased their water supply reliability by using this bond money, okay? We got $44.5 million in the local groundwater assistance program. So the people in the Delta and some of the people up here in the north, they may not have alternative sources of water. You understand what I'm saying? So when you're talking about the 1,500 cubic feet a second for health and safety purposes, I still haven't got answers for those questions. I still don't know how much carriage water the projects are saving as a result of not having to meet the standard or relaxing it. I don't know that. So in the absence of not having that information, I cannot stand up here in good conscience and give you some input that would be meaningful. I'm sorry, I just can't do it. So I'm saying that the emergency that we're looking at, and this is the 4th driest year in history. The problem that we have, Mr. Chairman, is that we had a situation where they were pushing more water out of the system in those years that just went by. You know, we were up to almost 6 million acre feet of water in 2012, you know, by the projects. So now we come back and we say, you know, in January, which we're only 16 weeks into the water year that we've got a crisis, the governor says we got 687 million, and less than a week later, or 10 days, 300 million of that has already been appropriated. Look, okay, we got to get a hold on this one because the people of the state of California are eating this one. It's not just the water districts, they're going to get over. I take exception to Mr. Howard, and in all due respects, I know Mr. Howard for decades. I do not see the emergency he's talking about. I see a fabricated emergency that's been exacerbated to a large degree by these water project operators who have yet to be held accountable. And if I was in the shoes of any of those guys out there or women out there, I'd have to say that I'd take you on. But anyway, let me just finish up here. I'm sorry.
If you could, Mr. Horgens, just because it's getting late. But
Yeah, well, yeah, I know, and I'm on a migraine right now, so, you know. And the only reason why I came here today was because I was stopped by a highway patrolman the other day, you know, who was telling me he wanted to protect the highways. I had a screen out my window, which I have 2 neurologist reports that I can have him on there. And I wanted to say, do you think you want to get a job over here at the state board? You know, because you seem like really diligent about enforcing the law. Because you guys just don't enforce the law except selectively. And on that last note, you know, with the 24-hour notice, those fish are probably going to be fried anyway, okay? Those fish up there on deer, and they're going to be fried. I don't see where they're going to make it. And if they make it to the pumps, they'll probably get sucked up anyway. So I'm saying the whole fish issue is fishy. And this water is a water grab. It's by the people who are involved with the department and the projects. And these people out here are they're trying to get them to pick up the slack. So anyway, if you can go along with that, hey, like one woman said, and another guy, pays the mortgage. Have a good day.
Feel better. Jeffrey Volberg, California Waterfowl Association. Did we lose Jeff? Chris Shearing, Farm Bureau. There you are.
It's late. I'm Chris Shearing, and I'm from the California Farm Bureau, which means I represent a spectrum of water users up and down the state. I've got some project guys, some non-project guys. I've got to be careful about which option I pick from that standpoint, because there's a significant.
But yeah, there are
project-
people on all sides of it,
Yeah.
since you represent everyone. It's
So I'll
an
be-
interesting conundrum.
I'll be quick anyway. I have a lot of questions about this, and there's certainly some things that my members would like to hear from me about, and I hope that those are fleshed out as we go forward. If I just had to hit on 3 things late in the day, I would reiterate what you've heard 100 times today about respecting the priority system of water rights. I don't think anybody disagrees about that. And if all this is an attempt to prevent, as Tom Howard said, illegal diversions of water, I think my organization could certainly get behind that, because we don't stand for illegal diversions of water. So to the extent that there's no reprioritization of water rights here through the carve-outs or through equitable concerns about who should be responsible for meeting the water quality objectives in the Delta, I think it's an effort we could stand behind, given the right due process. I realize there's a question about whether whether the water quality objectives should be all on the back of the projects, or they should be shared in some respect with respect to underlying natural flow. I can't opine on that, but I think there's probably a legal answer, and you should come down on the legal side of that and administer the water rights system according to strict priority. With respect to that due process, I think due process plays heavily into it, because there's so much argument here about whose water is what in the Delta and upstream. I know that. We've got different water attorneys in the room that have long had that running battle about what kind of water is being pulled. That argues in favor of due process. Concerned about an emergency regulation approach, concerned about any truncating of the opportunity for any water right user to have a full opportunity to be heard, a hearing, protest, whatever. I understand the need, of course, that you don't want to have to prove that no water is available in the system 12 times over for 12 different enforcement actions, but there has to be a reasonable balance of due process in there. And then the final thing I'll say is, to me, the biggest threat to the priority system here is the carve-outs. Maybe they're not a big deal. As Dan Kelly said, there is not an exception in California water rights law, as far as I know, for health and safety flows. On the other hand, I'm not going to be the guy that stands up here and tells you that people shouldn't have water to run their dishwashers or flush their toilets. I'll leave that to you. I will tell you that the public trust, and I can't tell how big a deal the public trust is in this thing, because it's only mentioned once in the entire document at the front end, and then each of the 4 options that are described don't mention public trust at all. But to the extent public trust flows are at all implicated here, I think that absolutely should not be part of any emergency proceeding, because that does require a balancing, as other users have pointed out. And then the last thing I'll say is that we certainly encourage voluntary sharing agreements. I've heard about a few. How many more are possible this year, I don't know, but please push in that direction. So that's all I have. If I had to pick a direction I was leaning in, which I don't want to because somebody will be mad, it would be that first option. So that's where I leave.
Thank you. Very thoughtful.
Thank you.
Chris Schutz, C-SPA. Hi, Chris. Thank you for staying.
Good afternoon. Chris Schutz with the California Sport Fishing Protection Alliance. I'm kind of surprised that I'm the only person here, I think, that's representing an environmental group. I don't understand that.
That's why I thanked you.
And
I was surprised as
so
well.
I'm going to ask for a little more time, and I'll try to keep my thoughts organized.
You're last, so.
Throughout the temporary urgency change petitions and orders, CSPA and our colleagues have emphasized process, and we've been very critical of the lack of process and the truncation of process within the requests the various requests by the projects for various variances and changes and temporary urgency changes. In that light, we looked at the options that you all put together for curtailments. And we were looking at two things. We wanted to choose an option that has the best, or that will most effectively maintain process, but also that will effectively do the job. And for that reason, we looked at option 2 as the best option. Not because we are in favor of limiting process, or that we don't believe in hearings, or that we still don't believe that you need to have a hearing on the temporary urgency change order, but because in some cases, and I think the Antelope and Deer and Mill Creek situation, at least as it was initially presented, is an example. There are emergencies and you have to do something, and if you don't do it soon, by the time we get to the point of going through the process, we aren't going to have any fish left to talk about. So that was the balancing that we went through. We've heard a lot today about how public trust shouldn't be part of your consideration here. Well, we vehemently disagree. We don't think that keeping a minimal amount of water in a river to protect public resources is in conflict with a water rights priority system. And when you all go to look at curtailments, that doesn't mean you get to divide up every last drop and run the river dry. Right now, today, at least late last week, the San Joaquin River near the mouth of the Tuolumne was running upstream toward the diversions of the West Stanislaus Irrigation District. And we've heard that the river may run dry. And if it takes what Herrick suggested to bring water from San Luis to keep water in the San Joaquin River, I guess we think that you ought to consider that. There are other options. We're concerned, hearing today about Water Code Section 1058.5, that was changed in a recent order, as someone from the board testified. We simply looked at it on its merits. We pulled it up off the web, and we said, okay, there's something in the code. There's process here. It's not simply dependent on the governor's proclamation, and there's some kind of order to it. So tentatively, because it's going to be the only option that can actually do something, we supported it. It's a big concern to hear that it was part of the sort of changing of the finish line and the goalposts in the drought itself. I'm not sure how to resolve it. When we looked at option 2 specifically, it says enforcement cases would only need to show that conditions of the regulations were violated rather than reestablishing the factual case on which the regulation was based for each enforcement case. That's this part of the summary there. And that was the part that caught our eye. Because otherwise, we don't think you have the staff or the manpower to go and enforce all the things that you'd have to enforce to do any curtailments. So that was that part of the of our concern. I think one thing that I agree with almost everyone in the room about is that option 3 is unacceptable. And Mr. Grover said earlier that option 3 and 4, the difference doesn't matter. Well, we think it does. Changing the rules about how the projects are required to have a special duty to meet water quality standards during an emergency is just a bad way to do business. It's something that you can consider, and to some degree it's been being considered in the update of the Water Quality Control Plan. That's the right place to do it. That's going to be a long and formal hearing process. And at least at some point, when you get to the water rights, and that's how it ought to be done. You know, as a practical matter, one of the things that 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 came up way back earlier in the day, and it's been a long day, and I'm sorry.
I thank you for staying.
But
It wasn't that long.
there was something said about how, well, because pre-14 folks are all going to be curtailed anyway, it doesn't matter whether option 3 or 4 would take place. But the difference is that is how you enforce the standards, and whether releases from project facilities are actually reaching the delta and meeting outflow requirements, whatever they are, or and what you do if they're not. If folks other than the projects are responsible for it, then you're going to start making more curtailments. I mean, that would be the logical thing to do, to curtail people farther back in the system, either people with earlier priority or riparians. Otherwise, the projects are going to have to release more water. That's the effective choice. And part of the responsibility of the projects is not just to meet the numbered standard, but it's to release that margin of water that's needed to comply. We heard in the Delta Flow hearings that what's hard is not complying, what's hard is to skate on the edge of compliance. And the urge to skate on the edge of compliance is harder and harder as the system becomes more constrained and less water is available. But still, it's got to be the responsibility of the projects. We do agree that real-time data is better. We considered adding that as something as a suggestion to modify option 2. And we're concerned that the data you have, there's some problems with it. I'll talk a little bit about that. What our concern about using real-time data was, in the past, when Term 91 has been applied, it's been applied very reluctantly. And you have an ongoing, protracted process by which you're being asked to take water away from folks or limit their diversions, and the more process there is, the harder it gets, and as a general rule, in aggregate, the environment ends up with less water. So if you have a way of integrating real-time data, that's good and it's better. When folks were looking at the different charts that Mr. O'Hagan had, both a tributary chart and a chart for the entire watershed, I mean, and this goes also to what folks have said about watershed by watershed or looking at the whole system. You have to do both.
Yeah, you do.
And you have to do both because a riparian diverter on the Tuolumne isn't going to be helped if there's more water somewhere up in the Sacramento. But on the other hand, you have to be cognizant, as Mr. Howard just pointed out, of the fact that a senior diverter from the gentleman who spoke from a Delta diverter a few minutes ago is being shorted water because water is not making it downstream.
Thank you. You're at 10 minutes. I
Okay.
just thought I would tell you.
Less than 2 minutes.
Less than 2 minutes.
Yes. We don't believe the TUCP is protective, and we don't think you should base anything in what you're doing now on that. And in our comment letter, we addressed a number of the other issues that are addressed in the questions here. I would say simply regarding health and safety that one of the overriding things that the board has is the right and the duty to determine what's in the public interest. And I would say that in some measure, although you have to look at priorities as much as you reasonably can, as the various courts have said, it's not absolute, and health and safety can be a factor that you take into account when you're making your determinations. I think I'll stop with that, and thanks very much.
Thank you. Thanks for
Questions?
staying, too. Brian Paulson, El Dorado Irrigation District. You don't have to talk about that case.
well, actually,
You can if you want.
Brian Polson, Deputy General Counsel, El Dorado Irrigation District. I was going to more politely and gently remind you about that case, but Dan Kelly did that for me. I would just like to make a comment about that. I acknowledge that Mr. Howard is correct, that central to the court's holding in validating the state board's application of Term 91 to EID's license was that it hadn't also done that to every other more junior appropriator in a water rights proceeding. It does not follow, however, that doing so to all appropriators in an emergency regulation does not also violate the rule of priority. If I could, I'll just read to you a passage from that decision, which was issued by the 3rd District Court of Appeals in 2006, Justice Ron Roby writing the opinion. To the extent the restriction on El Dorado's right to divert water serves to protect water stored by the projects for export to other regions of the state, the board has not shown that its interest in protecting the project's stored water is of greater importance than the rule of priority. And so I'll make a request and then ask a question. The request is that you proceed with caution as you consider applying Term 91 more broadly. I think that you run very high risks as you do that, and so I would just request that you proceed with caution. The question that I have is if the purpose of applying Term 91 as it appears it's suggested in the papers, is to protect stored releases from unauthorized diversions downstream. The question is, would it apply to water where the point of diversion is upstream of the project storage facilities, and if so, why?
When the projects are releasing stored water, it doesn't really matter where someone takes additional water.
Right.
The projects have to release an additional CFS for every CFS that's taken. They have to release an additional CFS of stored water. So Term 91 treats the entire basin like a lake. It doesn't matter where in this lake you are diverting because it's all aggregated by in the term itself. And like I say, the reason is that as somebody takes stored water with a water right priority of whatever, the projects then have to release an equivalent amount of stored water to make up for that water.
Right.
Well, I would just respectfully disagree that a diverter upstream of the storage facilities diverting under a priority which is senior to the projects would have to would require illegally that the projects divert or I'm sorry, release additional water to offset the water legally diverted under a more senior priority upstream, particularly if, as I said, the point is to protect those stored releases from being illegally diverted downstream of the storage facilities. So I'll just leave that point with you. And then finally, just one more point on the issue of reliability of information submitted. I really, the point that Mr. Rubin made really resonated with me. I think it's important for the board to acknowledge that agencies spend, and all diverters, frankly, but particularly agencies with diverse water rights portfolios, spend
which is quite a few.
tremendous amount of time preparing and submitting their water rights reports. This is a statutory requirement, and it is the state board that tells us what it is to report. So to the extent that you feel like that information is useless or inaccurate, I would just suggest that that you acknowledge and furthermore, this is information which is submitted under a penalty of perjury. So, I would just leave that with you to the extent that you feel like that information is not helpful. I would request that you help us make it more helpful to you so that we're not wasting so much time. And then secondly, I would just question why it is that information provided to you by DWR or the Bureau is necessarily more accurate than information submitted by the diverters themselves. Thank you.
I'd just like to clarify that I didn't, it was a misquote from Mr. Rubin. I don't think that I said that it was useless. It's just that there's better data that's real reporting this year versus what was reported to have been used in previous years, and frequently water users will report the same use under multiple rights, and there's a number of those kind of concerns, and there are also the unsophisticated water users submitting reports as well. So in no way meant to imply that that data is not useful. It is very useful. However, it's not data from this year, and so there's limited usefulness of the data.
Diane, what are you seeing on the trend, though? Is it when there are, when you have an opportunity to go back and correct the inaccuracies as a result of further discussion with water districts, et cetera, is it that you're seeing over-reporting in terms of demand?
I think that's the trend, yes.
So if in that situation, then a curtailment might kick in
Earlier.
sooner.
Or more
I think that's why
extensively.
it's important to ground truth that data, which the staff in working on in John's shop have been doing.
Yeah.
So it's not, we acknowledge, that we need to take a close look at the data and make sure that we believe it, and we are doing that. And so I'm not implying that's not good data once we work it up.
Questions, that's our last speaker card. I would like to actually stay. You did? Mr. Rentz. Sorry, I didn't see it. I thought you were just monitoring us.
I don't know.
But no, go ahead,
I guess
sorry.
I've been way too long. Thank you very much. Good evening. 28 hours later, 27 hours later on this discussion. I'll be very brief. Mark Rentz, Integrated Natural Resource Management. I'm not here today on item 12 to discuss or argue whether or not there's a need to further regulate the use and diversion of water on Mill, Deer, and Antelope Creeks. There's individuals you heard from today in this room, and there's those who haven't been in this room today that, if I provided the opportunity, could provide you much greater knowledge and understanding of those three